Good afternoon, everyone, and welcome to the Federation of State Boards of Physical Therapy's webinar on this beautiful June afternoon. My name is Michelle Thorman, and I'm privileged to serve as your Vice President of the Federation of State Boards of Physical Therapy. We're joined today by our friend and guru of all things legal, Attorney Dale Atkinson, who's going to be speaking to us on kind of a muddy issue for many of us, the distinction between federal and state authority and jurisdiction. We're glad to have you with us. Dale, thank you for joining us and for presenting this most important topic.
Thank you, Michelle, and I'll add my welcome to everyone as well. And Rich, I can see you. Thumbs up. You can hear me. Sound is good. Very good. And so, again, welcome to this month's regulatory hour. And as mentioned, we'll talk about this federal state authority. I think it's a very important topic for focus. Not only in the regulatory community, but I believe it's given rise to a lot of attention through the COVID era, through federal regulations that are either imposed or relaxed, as well as the state authority that has been addressed and otherwise. And so I'm hoping that you find the next 60 minutes to be helpful. Let me make sure my slides can advance. And again, adding my welcome. So the first thing I'll say is I'm a regulatory nerd, and regulators rock. So all of you folks on the phone, you all rock, and continue to do the good work of regulators. You need to be recognized more, and you're not recognized enough, which kind of leads me to my thank you slide here. And I want to reach out and recognize. One is your FSBPT Board of Directors for putting these webinars on, and all the other programs that are put on behalf of you all, the member boards of the organization. So remember, you are FSBPT, and you benefit from the collective wisdom, and the vehicle or the vessel that's being used is your FSBPT. This webinar and other programs and services are just examples of what can be accomplished through the collective wisdom of all of you as the regulators. So one is I'll thank the board of directors, as I've already said, for allowing these webinars to happen. I'm proud to be a part of them, and I'm all jacked about regulation. I'm a regulatory nerd, and so hopefully that will surface. And secondly is a thank you to your FSBPT staff for operationalizing and allowing these to happen. So a big shout out, thank you to Jeff, Rich, and the whole team involved. But the biggest thank you goes to everyone on the line today, whether you're a board member, a volunteer board member, whether you're staff, executive director, administrator, assistant attorney general, lawyer representing a board, and inspector, investigator, no matter who and what role you play, you need to be thanked. We're not thanked enough. The regulatory community is not recognized enough. And in part, it's because it's not known perhaps to as many folk as it should be. So as I give my thank yous, I also suggest that we as the regulatory community, figure out ways to continue the outreach and ensure that there is knowledge about regulation. So big shout out, thanks to each and every one of you. I start all my sessions this way and I end them all that same way. So you're going to get another thanks out of me at the end of this. So just make sure you're listening, make sure you're there, make sure you're engaged, and make sure you technologically know what you're doing, which is not my necessarily forte, but I think we can all chat. So let's go ahead and just type into the chat the corresponding number where you fit, whether you're a board member, exec, administrator, or an academician, trade, lawyer, or otherwise. And I just like to say the word academician. So, those in academia and education, it's just a kind of a cool word. So that makes sure that we know you're listening. One, it also provides good data to your staff at FSBPT as to who can attend these and perhaps what you're getting out of them. How can they be improved, and others. I will put in, while you're typing those in there, by the way, I'll put in the plug for topics. Please feel free to submit topics to Rich and the staff that you think are important in your world, because if you think it's important, it's probably important to most all of the FSBPT board members that exist. So it looks like we've got kind of a nice mix there as well, including a couple of others. So welcome and appreciate your information. So as mentioned, I'm Dale Atkinson. I'm the facilitator of this. I like to look at myself as a facilitator. although it'll feel like a lecture, and you guys will probably feel like I say a million words to get out a point that could be made in 100. But I will be guiding the ship through the course of our topic today. I only stop on this slide to make a couple of points. One is I'm an attorney in private practice, and I represent a whole bunch of FSBPT-like organizations. So I think the thing to get out of this is you're not alone as an organization of FSBPT. You have other groups just like you whose membership are comprised of the regulatory boards in the US or perhaps North America or even worldwide. But your organization provides programs and services designed to lessen burdens on state government. And that's what all my clients do. Most all of my clients develop, administer, score, and maintain a uniform licensure exam program. So you're not alone. And you're not only not alone as an organization, but you're not alone as a regulator. You've got intrastate, other boards within your jurisdiction. You've got interstate via FSBPT to have these communications. So shout out, thanks, shout out, welcome, and let's continue on with the topic itself. But we can't get by without a hockey reference, right? And so just go ahead and type in the chats whether you were rooting for the Golden Knights in the Stanley Cup Finals or the Florida Panthers. Everybody probably knows the series is already over, but you all have to have I suppose, an opinion on this. And as some of you who are veterans attending a lot of these have learned, if you talk about hockey, you're always right. And then we don't need to worry about all this regulatory issues that can get so complex. And so we got some Flyers fans, some Blue Jacket fans. Excellent. All right. So yeah, keep those chats coming. And seriously, on a serious front, if I say something or you have a question, type it in the chat. Rich and Jeff keep an eye on this, and they feel free to interrupt me. And ask the question if needed, or I suppose unmute and have a little more of a discussion as well. Neither. Oh, come on. There's a neither up there. I don't know. And lastly, this is all warming ourselves up to have a nice discussion. What's the last live concert you attended? I'm a giant Steely Dan fan. It's been a while since I've been to a concert, but feel free to type that in as well. Now we know you're listening. Now we know you're engaged. And then Van Halen, nice, the Eagles. Cool. All right. So on to our topic. And keep typing, keep those in there. I like to watch those roll past as well at the same time. So we'll talk today about the role and the authority of the federal government vis-a-vis state government in this arena of professional regulation. And as I've mentioned already, this is a really important topic for a whole lot of reasons. Not only the fundamental basis of the governance structure in the United States, but how it might generally affect you all as state boards, and infringe isn't the right word to use, but may affect your role as a regulator at either issuing a license, renewing a license, or perhaps removing a license and otherwise. And so we're going to get into this. It's kind of a deep topic, but we skim the surface, but feel free to continue those questions coming in. So Blue Oyster Cult. Now there's a cool one. And Bob Seeger. All right. Excellent. So is physical therapy a profession? You can feel free to type it in if you want. You can nod your heads. I think I know the answer to this. I think that I know the answer you would give. But I was just telling Rich a few minutes ago, I just finished a presentation earlier today on what is a profession. It was really eye-opening for me to do research on this. I thought I knew, or I think I know, and I can identify terms and phrases that indicate what is a profession, but I found legal cases that actually discuss the distinction between trade, occupation, and profession. So it was eye-opening for me. And I bring that up because professions are state-based regulated under the 10th Amendment in the United States. And so that is a good distinguishing factor between where does the federal government step in versus, if you will, where the states have their rights granted to them under the Constitution and the Bill of Rights. And so, again, I'm sure everybody's going to say, yes, it is a profession. I agree with that. And I will say this, that there has been a court in Nebraska. The Supreme Court actually in 2013 ruled that physical therapy is a profession. And it was confronted, if you will, with the issue of the statute of limitations. And without getting too deep into the legal issues behind it, professions in Nebraska, a negligence or malpractice complaint has to be filed within a 2-year period if it's a profession. And if it's not a profession, it may not be a malpractice case, but it's a negligence case, and I'm not sure what the statute of limitations is. But in this particular case, the court ruled that physical therapy is a profession as related to that statute of limitations. So little foundation there. This is a state-based question, and it was answered by a state Supreme Court. And yes, Nebraska physical therapy is a profession. I agree with that. It may not be a surprise to anybody on the line today, but it's interesting to see the judiciary write about it and how they identified what is a profession. So that may be a topic for the future, Rich and Jeff, but something at least to think about. So the fundamental basis for the topic today is really driven by the 10th Amendment of the U.S. Constitution, that the powers not delegated to the United States belong to the states themselves, or the people, it actually says. And this forms the basis for state-based regulation. And a consequence of this, whether we like it or not, or whether we want to be critical of it or not, is each state determines how best to regulate the professions within their respective jurisdictions. And so that can lead to inconsistencies, and that can lead to what might seem to be barriers or deterrents to either mobility and or the achievement of licensure itself to practice any trade, occupation, or profession. So wherever it falls. But that is a consequence, and it is a recognition of driving decision-making down to the state level rather than elected officials at a national level. And, you know, the founders, if you will, and the writers of the Constitution and Bill of Rights thought that through. And this is a really important concept that has guided the regulation of the professions since many, many, many years ago. And the seminal case was a United States Supreme Court decision called Dent versus West Virginia, decided in 1888. And here a physician, well, maybe I can't call him a physician, someone who was practicing medicine without the required certificate in West Virginia was indicted and criminally prosecuted. And he argued as his defense on appeal that the state didn't have the right to do that, and that he had a constitutional right to pursue his chosen profession, if you will, or trade or occupation, whatever you end up calling it. And the Supreme Court disagreed with that, upheld the criminal conviction, saying that the states under the 10th Amendment have the right to what are called police powers, and those police powers allow each individual state to determine regulation of the professions themselves. And so this is the seminal case. This is what formed the basis for probably recognizing this state-based licensure system that we live in. Now, as I've mentioned, you may not agree with it, and I get questions all the time. Why isn't there a federal license? And some people might refer to that as a national license. And again, most of the answers are going to be driven by Dent versus West Virginia and ultimately the 10th Amendment of the Constitution. So those rights are there, and they exist, and they should be respected and recognized. I will also say this on behalf of not only FSBPT, but all my other clients, and that is why your organization exists. They can provide some of these benefits to each state to allow you all to use information, programs, services, profiles, registries, examinations, whatever, in a collective manner to promote some uniformity, if you will, but with respect for that 10th Amendment. So this is why the FSBPTs, in my mind, of the world actually exist in large part. And this is the role that they play and they fill by allowing you all to collectively get together and provide programs and services to make you more effective and efficient. So 10th Amendment, Dent versus West Virginia, keep that in mind. Now, what I think is the impetus behind this topic, and sometimes FSBPT asks if I have some topics, and sometimes they say, hey, can you talk about this? And this maybe was a little bit of a combination, but I think the impetus behind this topic was this recent federal legislation signed into law by President Biden on January 5th, I believe it was, of this year. I think it was effective immediately. I actually didn't look up the effective date, but it is effective. And it relates to the portability of professional licenses of service members and their spouses. Now, I want to make sure I say out loud that I have all due respect for military, law enforcement, all the individuals that it takes to keep this country secure. And so my questioning of some of the legal issues that you're going to hear in a little bit are with all due respect to a system that allows military personnel and their spouses to more readily move about the country as they are through military orders asked to go to multiple places, and it happens quite often. So at least with that foundation, there are some questions about the legal aspects of this legislation that I'm about to talk about. So I want to make that clear that this is obviously with all due respect to that. So this section 4025A, portability of professional licenses of service members and their spouses. And I will add to this, by the way, again, with all due respect to the military personnel and spouses, is that if there are systems that can be created that make it more efficient for these military folk to get licensed, hopefully some of that spills over to everybody who wants to get licensed so that there's an efficiency factor taken into consideration. One of the biggest criticisms in the regulatory community across professions, and I'm involved with a lot of them, is the inefficiencies of government, if you will, boards, departments, composite boards, whatever it is you are, the inefficiencies of licensure processing and issuance. And I realize there's criminal background checks and others that may slow the process down a bit, but these inefficiencies, as they surface, the policymakers are going to make decisions on data that may not paint the complete picture, but if they hear it takes 9 months to get a endorsement license issued, someone is going to say perhaps that's an unreasonable amount of time. And so federally, the government now is stepping in under this particular section. So this portability issue and the bullets there on the right there, and I tried to summarize it. It's not a long piece of litigation. You all can read it without falling asleep, I'm sure, and see some of the issues that surface. But it applies to service members or their spouses. And a question just came up over the weekend at a different conference about, is this active service members or others? And I think the answer is yes, without it saying active service member, because part of the requirement here is driven by the fourth bullet down. The relocation is due to a military order. And I think those military orders apply to active service members as opposed to any of the others, but applies to service members and spouses. It is a covered license, which physical therapy is, and covered license is defined, and it's a very broad term, as you could imagine. The license has to be in good standing. So now, whenever you read legislation, by the way, whether you're talking about your state legislation, whether you're talking about rules, regulations, bylaws, whatever it might be called in your jurisdiction, or whether it's federal law, you should always pause if you see a term or phrase that you're not sure what that means, okay? So I see this and I stop at, well, what's a service member? Okay, what's a spouse? We could ask what those are. And is marriage the issue? Common law marriages, do those count? Live-ins, contractual marriages, contractual relationships, whatever you might want to call it, we're going to have to ask that question. Covered license is pretty self-explanatory, but now in good standing. I ask this question of boards all the time. What is in good standing and what does that actually mean? So when we have laws like this, we have to step back. You, the regulatory community, have to step back and say, okay, what does that mean? So if I have a license, I had let's call it a minor record keeping issue, and I'm put on probation for 6 months, let's say. I have no loss of privileges of practice or anything else. I have no restrictions. And is that license in good standing while it's on probation? I'm not sure I know the answer to that. I think I would say yes, but you all have to decide that at each jurisdictional, at each state level, if you will. And the interpretations of in good standing may be different from one state to the next state. So And, by the way, related to terminology, state is with all due respect to commonwealths and territories and districts and everything else. So state is my generic term, as is license, as opposed to certification or registration or something else. So in good standing, stop there, figure that out. What is in good standing? If anybody wants to type in, if you know what in good standing means, type it into the chat and tell us all what it is in your jurisdiction. That would be helpful. The relocation, the next bullet, has to be due to a military order. Okay. And you have to be moving from one state to the next state. So it's a different state, not intrastate military relocation. Now you get into the meat of this on that next bullet. The covered license, so let's just use the physical therapy license, and we could use PTA, I suppose, here as well. The license shall be considered valid at a similar scope in that second jurisdiction. Okay, we're going to come back to that point. So put a pin in that. Just think about that for just a minute. For the duration of the military order, this applies. So I'm relocated, military order. The license is considered valid. And I'm not exactly sure what that term means, but we'll debate that in a minute. And the last bullet there, it does not apply to lawyers. So lawyers can't take advantage of this issue. Shocking, right? And lawyers get exempted out. Usually it's lawyers and physicians that somehow have a separate category where they live. And by the way, just not being in defense of lawyers, but the lawyers are governed by the judicial branch of government, not the executive branch, and combination with the legislative branch. So that may be one of the reasons why, but be that as it may. So we do have in good standing. I'm going to read this here. A person who holds a current valid, and have to be Louisiana license, who is not subject to a board order or consent order, and whose license is not restricted, and the board is the ultimate decision maker. Okay, excellent. So start to think about that, because this question is going to surface if it hasn't already. And it usually should surface anyway, whether you have a compact set up, whether you have an endorsement set up, a profile / registry set up for mobility and portability, whatever. You're going to have to know what this is. And now it's being brought to the forefront via this federal legislation. Now, the federal legislation now, according to the data that the Department of Labor brought forth and that the legislature looked at in enacting this statute and then ultimately having it signed into law, said that the professions that are most represented through military personnel and or spouses, and I think it really limited to the spouses, but it could be the personnel too, are listed right there. So healthcare issues, nursing, physician assistant, EMTs, paramedics, pharmacists, and physical therapists. I underline it in case you didn't see that. Jumps off the page at you. It's your world. Teacher, real estate agent, social worker, massage therapist, and cosmetologist. And so there's a recognition of this, and the numbers are probably bigger than you think as to the number of personnel, service member and or spouses. And they say that 130,000+ active military spouses maintain professional licensure. That's obviously a big amount there. But I've already said this, but the slide emphasizes that in part this legislation was stimulated by this length of time for issuing of a license. And don't forget, in these cases, it's someone who is already duly licensed elsewhere. Now, in your world, just like in most of my clients' worlds, but not all, but most of my clients' world, you have an accreditation process for education. You have a uniform licensure exam. You are well on the way to uniformity. There may be some criminal background issues, good moral character issues. You file an application, you pay a fee, but the meat and potatoes, maybe I shouldn't say it that way, but a large part of what you all consider related to licensure eligibility is covered through this uniform process of recognition of education and recognition of an entry-level competence determiner, your examination program. And so how much time should it take for someone who has been through that to get a license in jurisdiction number 2? Anyone, by the way, whether they're military personnel or spouses or anyone else, what have you. So you can think about that. You can see on that last bullet there, and there's, I just read articles about this, so I didn't do any research necessarily on this, but the articles were talking about it takes up to 9 months to obtain a license by, and what I'll use is endorsement. A lot of people say reciprocity. It's not really reciprocity, but that's just sloppy use of terminology in my mind. But 9 months, can you imagine that? Whether you're military personnel or anybody else. No wonder people might complain. No wonder policymakers or legislators or elected officials or politicians, whatever you want to call them, sit up straight and ask the question, well, gee, what's going on? Why does it take so long? And hence, this is in part why this legislation was enacted, at least in my opinion. But the question now is the application of that law federally, imposing issues upon the states. And we're going to get to that in just a second here. So the federal law, by the way, also defers to an interstate licensure compact that may exist. And so if there is a compact situation where a military personnel, service member, and or spouse are moved from a compact state to another compact state, the legislation recognizes that, and the compact, if you will, governs the relationship or the issuance or the recognition of the lawful authority to engage in the practice. And I think everybody on the line probably knows enough about compacts, but compacts can be one license recognized in multiple states. It can be a fast track, if you will, endorsement where you get licenses in all those compact states, but it happens very fast. So there's some variations, but I believe, and Rich, correct me if I'm wrong, the compact in physical therapy is a one license recognition. So anyway, so this legislation, federal legislation, recognizes the existence of compacts. And I think that's kind of feather in the cap of all those who are heading down the compact road, because they're becoming more common than they used to be in the world of professional licensure. Compacts have been around for over a century in recognition of water rights and state lines and other things. So, but now they're gaining, if you will, in their momentum in the professional licensure world, your guys' world of licensure itself. So anyway, it refers to the compact itself. Now, I'm a stickler when it comes to language within statutes and regulations. I assist all my clients in their model acts, their model practice acts that they have developed on behalf of the members as a resource. FSBPT has a model act as well, so feel free to look at that and make sure that you use that to the extent it is beneficial to you as a member board of FSBPT. But the importance of language. So as you read this statute 4025A or any other statute, you should pay attention to the language and the words that are used, and the lawyers will want to interpret words if they're included in the legislation. And so if it says rules and regulations, I'm going to ask, there must be a difference between rules and regulations because they're both referenced in the statute. And, sometimes it's sloppy drafting and otherwise. But so as you read this, look at the language of the legislation itself that exists. And it uses the word license. So what's a license? It actually uses the word certificate. Well, what's a certificate? Because it says license or certificate, I believe. And so I am going to ask, why are both of those terms used? And perhaps it would say license, certificate, or registration. And however it is, they're there for the language is there for a reason, and it should be interpreted as such. Certification might refer to the assistant program, as you're certified to distinguish between a physical therapist who may be licensed and otherwise. So it could be actually being well crafted, taking into consideration the varying terms that are used in the member board states. So, but recognize, transfer, in good standing, we could probably pick out a lot of terms we've already identified. But as you read this legislation, as I mentioned, it's short, or as you read any other statutes and or regs in your jurisdiction, you should pay attention to that language and the importance of it itself. Certainly keep that in mind. Now, in order for an individual to take advantage of this legislation and have the license in one jurisdiction recognized or considered valid in another, the applicant, the spouse, or the military service personnel has to provide a copy of the military order to you, the licensing authority. I've already mentioned it must remain in good standing, and you must submit to the authority of the regulatory board in that second jurisdiction, that second state. So it's, again, there's very few words in this statute, but it does impose, if you will, and I don't mean that in a bad way, but it does impose obligations on each of your boards to recognize that license and allow someone to practice. So the ultimate question might be, well, do we issue a license in the jurisdiction 2, or do we recognize the license from jurisdiction 1, and how does that work? And right now, the legal community doesn't seem to have consensus on what the answer to that question is. I would suggest, if I were asked this question, is that jurisdiction number 2 issues a license, because it's a lot easier to enforce, if you will, any adverse actions, renewals, CE, continued competence, whatever, based upon a license issued by your board, state number 2, rather than somehow try to say we're going to rely upon what state number 1 does and says. Now, I say that, I try to say that very carefully. It's not that you don't trust your fellow jurisdictions, but it's a matter of legal jurisdiction over the activities undertaken by that particular individual. So recognize or issue a license or something. Your lawyers are going to have to chime in, and this is going to be a question that will be debated, I'm sure, over the course of the near future as these military personnel and spouses, move. Now, to go back to my emphasizing about the respect for the military and a process that provides portability and mobility in an efficient manner, with all due respect to that, the question here, I believe, is this legislation enforceable? Okay, and I'm going to tell you why in just a minute, but step back and reflect for a minute. Can the federal government impose upon the states a mandate to recognize a license issued by another state as being valid? And by the way, it's valid for the similar scope. So it does actually say similar scope. So if you have differing scopes, so if there's a few states, Rich, I think that can physical therapists can prescribe, but that's just one example. Whether that may be a bad example, but I'll use it. If you can prescribe in the first jurisdiction and you can't in the second, and your military orders take you to the second, you can't prescribe in the second. So it's within the scope of the state jurisdiction where you're going. So at least keep that in mind. So now I'm back to my question: is this legislation enforceable? Can the federal government impose upon the states under the 10th Amendment and an interpretation thereof this recognition of licensure? Now, we all know there's a VA system, and we all know that on federal military property, that's a different question. And generally you can have one license in good standing and practice on any of the military installations around the US on that one license. This is a very different question because it allows general practice. I can be a physical therapist in state number 2 and practice on the general public. And what authority does your board have in state number 2, et cetera? So we can ask these questions, but so is this enforceable under the 10th Amendment? And that's going to be remaining to be seen. I have my doubts myself, and while I think it's a great program and it has all the right intentions, it may, in my mind, run afoul of that 10th Amendment. Now, Amy and I this morning, in preparation for this, had a big old debate about. Amy is an attorney that works with me, and she thinks it is enforceable, and I said it wasn't. So I said someday we're going to have a debate in front of an audience to figure this out. And she's way smarter and tougher than me, so I'm guessing that side may win out. But it's worthy of discussion. It is truly worthy of thinking about whether, again, this under the 10th Amendment, there can be this federal law that imposes upon the states the recognition of a license on all areas of your jurisdiction, not just military property, if you will, federal military property. So let's talk about maybe an analogy we can think of. And I've often talked about this topic, but it's been a while and has resurrected in my mind these questions of forfeiture statutes or otherwise. And well, you all may say, what's this got to do with anything? Let's see if we can tie this together. So here in this 2020 case, a nurse's license was subject to forfeiture as part of a criminal court order. Okay, so now we have a court, the judiciary, taking a license away. Okay, and it was based upon the fact that the property interest in the license was used in a manner to commit or facilitate the commission of these crimes. Okay, and this probably happens more than you think, where courts step in and order a license to be removed or suspended. And in preparing for today, I kind of stumbled on a lot of cases that I used to talk about where it happened, and it wasn't necessarily always a high profile criminal case. It might have been a lower profile, lesser of an issue, but where a court, whether it's federal or state, stepped in and suspended a license. You can't practice for a year or something like that. And I've always asked the question when that happens is, do courts have a right to do that? Okay. And I think the answer is yes. Maybe the more important question is should courts do that? And I think if I were a judge, state or federal, by the time a trial's over, criminal or civil, malpractice or bad crimes, whatever we're talking about, obviously I'm going to know that the defendant is a licensee in a profession. Oh, this is a physical therapist, that we're dealing with. And my court orders that might be entered, assuming I had this authority, which I think I would be to ensure that I refer this to the physical therapy board to take action based upon the criminal conviction or civil malpractice conviction, whatever it is. And I would enter an order that temporarily did not allow that person to practice subject to the ruling of a board. You're the experts. I would want to defer to you, not only because you're the experts, but because you all would control when you get the license back, if ever. Mm-hmm. If a court suspends a license, well, do I have to go back into the before the judge to get it back, or do I go to the board? And how might that work? And so there's this deference that I would have as judiciary to ensure that you as a board were involved somehow. I'd try to figure that out. But here, this individual was forfeited their license as part of this criminal conduct. And so the question is that forever? Can the board issue a new license? Which, by the way, while I'm on that topic, at any point in time, you as a regulatory board remove a license, suspend a license, revoke a license, assuming you know what revocation is, or otherwise, individuals subject to this adverse action by your board do not get a new license. They seek reinstatement of a disciplined license or a license subject to an adverse action. So it's the same license number. So 10 years from now, when none of you are on the board or your exec has changed or whatever, it's the same license number, and there's a chain that can be looked at to ensure that informed decisions are made based upon historical issues, right? Doesn't mean you're going to not give a license, but you want it to be made on an informed basis. So that new license issue, a license subject to an adverse action is always a reinstatement petition, always. And so, keep that in mind from a process standpoint and make sure you ask that question. And I just talked over the weekend with a different group. I just talked about a case and I should have put it in. I just didn't put it in the PowerPoint slide, and I should have now that I think about it. And it dealt with an optometrist who had a license subject to a 1-year suspension, just like in this case, based on criminal conduct. Okay. And that was part of the criminal order. The optometrist complied, sat out a year, and then went back into practice. And as soon as that the optometrist went back into practice, the board issued a complaint and suspended the license for 2 more years and then 5 years of probation based upon the criminal conviction. So it's like, oh, wow, now what? So obviously, I think you all would think, is that double jeopardy? Can you can you impose an additional sanction that's not double jeopardy? So your administrative world doesn't live by the double jeopardy rules of the Constitution. So you can do that. There were some fairness arguments that were made and everything else. And sorry if you all can hear a plane flying over, but there's some fairness issues and others that were argued unsuccessfully, and the board was able to suspend that license on the heels of a criminal suspension that was served. So it's kind of that same issue of here, you know, what can the courts do? And here, obviously, what can the federal courts do in relation to that? So again, I feel like I used a lot of words there. Did I make a point? You guys with me? You understand that so far? So now we turn to the issue of, and in this case, this is a forfeiture. This is a giving up a license. It's a taking a license away. It's subjecting some kind of a sanction by the courts, federally in this case, upon a license. Now we're really answering we're confronted with the question of what about granting a license or recognition of a license via federal law? And that's the question on the table. And maybe this should have been the first slide, but it also maybe needs to be here at the end to remind us. This is the issue we're talking about. Can this legislation, even though it's for military and spouses, can it impose the obligation on a state to grant and or recognize a license from another jurisdiction, another state, as a valid entry, if you will, into practice on the residents of all within your jurisdiction? And that's going to be a difficult question, I think, to answer. I think this law will get challenged eventually, as politically, it will not feel good for someone to say, you know, we're going to get in the way of military spouse portability, you know. But I think if we step back, the bigger, more important question is the right of the federal government here. And so it'll be an interesting debate. You know, Amy and I, I'm sure we'll have a knockdown, drag out discussion about it, you know, in front of an audience at some point in time. But, you know, keep your eye out for what may be a challenge to this law. But in the meantime, it is good law. And so understand that you now may be dealing with issues of military and spouses, license in good standing, whatever that means, in another jurisdiction, coming into your jurisdiction and being able to practice, if you will, immediately based upon this federal law. So there's a lot going on. There's a lot of legal issues and others, but this is truly a stay tuned issue because there will be more to come on this as enforcement of this law is undertaken. That's one. But two is, more importantly, is for everybody on the line today, how are you going to deal with this? So you need to be set up to address the military orders, to address the in good standing question, to communicate with your fellow boards. FSPPT could be a perfect vehicle for this, to ensure you have the information to comply with this law, and at the same time, make your systems as efficient as possible for the service members and spouses. And while you're at it, I would strongly suggest you think about the efficiencies for all. And your compact steps in here, but until you have, and I'm not sure how many are in your compact right now, but until you have, you know, the vast majority within a compact, you're still dealing with these efficiency issues of seeking and getting that, if you will, second license. So it's a very important topic that's had here. I don't know if anybody had, so I see 30 states, active states in the compact itself, which is a terrific statistic based upon some of the historical compacts. So congratulations on that. And compacts will somewhat offset a lot of the questions I just asked about this legislation. But does anybody have any comments or questions or challenges or anything that you all want to bring up related to the topic? And I think you have the ability to unmute. If you want to just ask a question, you can certainly type it in as well.
Thanks for the information. I have a question. My name
Sure.
is Sam. Work in Ohio, and we have the compact. And I'm thinking about working for a group that does telehealth, and they've said I can utilize my compact to reach into other states and treat somebody from another state that has a compact, but do I have to get a license over there?
So, and Rich, make sure I answer this correctly. The compact for physical therapy is a recognition of a license in good standing in Ohio, allowing you the privilege of practicing in other compact states without having to get any type of a credential. That's correct, Rich?
Yeah, he would have to have a compact privilege for each and every state where the patient is located. So if you're doing telehealth, you would need to know where your patients are located. You'd have to have a compact privilege for those states.
Is that something formal I have to get from somebody or the state? Or?
Yes. So we'll drop into the chats the link to the PT Compact, which is going to have all the information you need to be able to learn more and get compact privileges.
And I see North Carolina already has 5 in process under this new legislation. So, it's there, and it's, like I say, it's a very positive thing. From a legal standpoint, it's perhaps subject to some debate.
So that's a prearranged kind of thing then? If it's already there, you just have to access it somehow, or?
Sam, if you email me at
Mhm.
info, and I sent you a private chat, I can sort of give you more information offline about the process to purchase compact privileges. But ultimately, you would need to get a specific privilege in each state in which you wanted to provide physical therapy via telehealth.
Oh, I got to purchase it. Okay, thanks. Yeah, you could give me your email.
Sam, thanks for your
Oh, there it is.
question. That is a more common question than you realize. And we hope that the resources that the FSBPT and the PT Compact have posted on the website are available and helpful to you, and you can pass them forward to others.
Great. Yeah, I got your email. Thank you.
I've got a comment from North Carolina. This is Kathy Arney.
Go ahead.
So when I said North Carolina has 5, I meant we now have 5 different methods by which military members can become either licensed or have some sort of privilege to practice in North Carolina because of the new federal law. And that basically gives us 2 more processes by which military members, expedited practice privileges can be issued. So, it's a lot. And to your point, we kind of have one person managing it because you really have to spend a bit of time understanding each person's individual circumstances. And we do not have this electronically programmed yet. So it's a paper process for the most part.
And Kathy, are your 5 processes consistent?
Well, to the extent they can be, our state changed the state law related to military trained people, active military members and spouses, and veterans spouses about 3 to 5 times over the last 5 years. So we had kind of 3 tracks that a military member could fall into already. And then now we've got 2 more. So it's I never thought about the question about whether the federal law really, has the ability to tell the states what to do. So we just implemented it because it was a federal law.
And without looking at the North Carolina law, this federal law may, and preempt is not the right word, but if it's the easiest route, you may not need the others.
Yes, and that's true. And we're trying to channel people into that. We just need to know that they are, that they qualify for that.
I think Adrienne Stacy has her hand up.
I just have a comment as well, just to say here in Georgia, the law that we already had on the books related to the military is a lot similar to what the federal law states. So we haven't necessarily had to make any additional changes to our processes as far as expediting licensure for those individuals. The one thing that I have encountered since this law has gone into effect, the federal law, is that the military persons don't seem to quite understand what the law does. So they call demanding that you've got to give me a license because the federal law now said so, when they don't really understand that they're, they have to have certain qualifications still in order to be eligible for one. So
Yeah, I'm very interested in hearing, and nobody needs to comment now, but on this good standing question as well, Stacy. So, how that's interpreted by both the state in which you are leaving and interpreted by the state into which you are going. Do those coincide, and what carries the day if there's a question about in good standing?
for us, the good standing portion is spelled out a little bit more in our statute, which basically is interpreted that you're not under investigation in another jurisdiction and or disciplined in another jurisdiction. And once you have that on your record, then you fall out of the expedited process.
Got it. And I hear that too. I hear the word discipline a lot. And there are boards that in their wisdom issue what they want to call non-disciplinary orders. And so they try to build that in too. So, it's not always an easy question. I agree, Stacy, that that language probably should cover everything, but it's obviously subject to some interpretation and potential debate. So, Leslie, I can see a hand up.
Yeah, Dale. So some of my counterparts from other organizations, we've been talking about this law quite a bit and seeing how. So one of the things right now is, although the law has passed, it actually hasn't been assigned to a department to have regulations written about it in order to implement it or clarify it. So, I mean, where does that put the states also with the fact that there is no guidance on how to implement it? And actually, at this point, they haven't even decided which department is going to get this law to write the regulations for it. So although the law is passed, there aren't any regulations that go along to implement the law and clarify the law. So where does that put us?
Yeah, and that's a really good point from the perspective of enforcement. What's going to happen if you don't comply, and a jurisdiction say we don't know how to comply, because we need the details through promulgation from regs. And there is where I think Georgia or anyone else who already has a law comply with your state law, and it's probably going to be in compliance. Assuming you have a similar law, it's going to be in compliance with the federal law. But that's a really good point, because I'm guessing those regulations won't come out. Call me in 2030 and let's see if they're out by then. See what's going on.
Yeah, especially because they haven't made the decision even who's going to implement them. They're looking at Department of Justice, Department of Labor, and Department of Defense. All three of those are potentially up to receive the law in order to write the guidance, and it'll be interesting. It'll be really interesting.
Right. And technically, and this happens all the time, by the way, laws are enacted until they have the regs that come out. No one really knows what to do, but I would treat it as being enforceable. You just don't know where that enforcement may ultimately come from. But to be enforceable, it has to have enough meat on the bones of whatever. So, I think that's kind of part of this. Stay tuned. I'm not sure where we're heading with this either, but that's a really good point to bring up. And your attorneys will weigh in on this for everyone on the line today. Make sure you follow the advice of your lawyers.
Good. Leslie, not to put you on the spot, but you've got such a unique perspective as a military spouse. Have you observed this law being implemented with other military spouses or people within your orb?
Yeah, so actually, I just became a Facebook group member of military PT spouses, and they are like losing their minds because they're calling the boards and they're like, we told them we're supposed to get a license and they don't even know about this law and they don't know it and they're not helping and they're not. And so they actually went through APTA staff who then channeled it to us, and I was able to go speak directly to the group, the owner of the group, and then get into the group and help to respond to some of the questions. And I said, trust me, all of the boards are aware of this. I'm like, literally some of the boards have, emailed me asking for help and understanding on this law. And so then I went into the fact that although the law is passed, there isn't any information for the board specifically about exactly how to implement this, and that the regulations that help to clarify the rule or the law haven't been written. So it's hard for the states to implement it. And, that many of the states already have processes in place for military members and spouses, and that, they should look into that. And so, yeah, just kind of trying to calm everybody down. But it's not just PTs. It's obviously, as Dale said, it's a number of different professions. And the other thing is that the folks are trying to figure out, although DOD has jurisdiction over the service member, they actually do not have jurisdiction over the spouse. So for them to have created this federal law, like federally, there's jurisdiction over the member, but does the federal government actually have jurisdiction over the service member's spouse and being able to include them in this law? So that was another question, and I think another point of contention about whether this is actually gonna hold up to scrutiny.
And I might suggest, I think the answer to that is yes, based on the recognition of marriage, assuming that's what spouse means. But that's an interesting question as well. So we'll watch out. And by the way, to your earlier point, I'm glad to hear that you all feel that the FSBPT member boards know about this, because the last several meetings I've attended, they don't know about it. These are other FSBPT like organizations. And so there's a lot of education to be had in addition to the questions that still remain. So I applaud you, FSBPT, for getting this word out to your members. So that's good to hear.
Absolutely. Thanks, Leslie. We have about 3 minutes left in our presentation. Does anyone have other comments that they would like to share?
And if it's quiet or if something comes up, happy to continue the discussion. But I will say thank you to each and every one of you, not only for being on the call today, but for the role you play, the important role that you play in consumer protection, fulfilling the intent of the legislation through regulation of the profession. And you deserve a big thanks and a big round of applause from me. So I give that to you. But Michelle, thank you for hosting today. And Bill and Rich and Jeff, thank you for the staff, and make sure you send my thanks, Michelle, to the rest of your board of directors. So appreciate it.
Wonderful. Dale, you're one of a kind. We cherish you in these presentations. I always think it's a good presentation when you leave not necessarily with all your questions answered, but you're asking better questions. So to that end, if you really like today's presentation, Dale's got another really murky topic coming up in August, on August 16th. Telehealth, mobility, and regulation. What is universal licensure anyway? So make sure you come well prepared to have a little headache in the middle of that, and we'll see what we can do about asking better questions for that one too. Also would like to remind everyone we have the candidate forum online on July 6th at 7 p.m. Eastern Standard Time. So we hope that you can log in for that and see our worthy candidates present themselves. I think that's all we have this afternoon. Thank you again for coming to us on this lovely summer afternoon. I wish you the best of summer before you and look forward to seeing you again.